thank you all so much for joining us today for our PowerPoint presentation on how to obtain a green card based on employment. We're going to be touching on a variety of green card options based on employment, including the EB1, A, B, and C, the EB2, the National Interest Waiver, as well as briefly a few other areas, although the focus will be on those areas. We are very fortunate to have our managing partner, Kelly LeGrand Weiner, to present today. Kelly has a wealth of experience representing clients who are pursuing these green card options, as well as a variety of other options. So we're very fortunate to have her here today. A few housekeeping items before we get started. We do try to do at least 1 or 2 webinars a week, and these cover a variety of immigration topics. So though our firm does focus on business immigration, we handle the full spectrum of U.S. immigration law, whether that's non-immigrant visa options, including the E2, the TN, the H-1B, as well as family-based green card options, whether through marriage or through a family relationship, or humanitarian options. So regardless of what your immigration journey presents you with, we do hope that you'll reach out to our firm for assistance. If you have a question during today's presentation, please do feel free to send that in through either the chat function on Zoom or the Q&A function, and I will be monitoring both throughout the presentation. We will likely share questions for the end, but either way, we do plan to get through all questions, so please don't hesitate to send those in. This webinar is being recorded, and we post our full-length webinars to our YouTube channel, which we hope you'll take a minute to check out after the presentation. Not only do we post our full-length webinars on, again, the full spectrum of immigration topics, but we also post shorter videos. And we really do aim to provide high-quality information for completely no cost. And we do sincerely hope that that's helpful to you all. So check out our YouTube channel. You'll be receiving an email after this presentation with a link to our YouTube channel, as well as a link to our blog where we post additional information, as well as a link where you can sign up for future webinars. So with all that being said, I am going to pass it off to Kelly to tell us a bit about employment-based green card options.
Thank you, Dustin. Perfect. So we're going to talk about some, not all of the employment-based green card options today, but have kind of a slide here that goes over several of the main categories. So we have the EB1A for people of extraordinary ability, people who have risen to the very top of their field and have achieved sustained national or international acclaim. And if you are interested in that type of green card, we do have webinars that specifically talk about all the extraordinary ability visa categories, both non-immigrant visas, and permanent green cards. So I would encourage you to check those out either on our upcoming events or also on our YouTube channel where we have prior presentations that we did. Another option is the EB1B. This is for outstanding researchers or professors. There's also the EB1C, multinational manager or executive. So very often people who are on, maybe an L visa, they've been transferred from abroad as a manager or executive, they may qualify for this, this green card category. And the benefit right now of the EB1 category is it's one of the few green card categories that is not backlogged. Most of the categories right now are undergoing some amount of retrogression, even in the worldwide category. So, very right now for nationals of India and China, the EB1, it could still be backlogged, but worldwide it's current. But in many of the other categories, it is not current, which means there's a wait, for a green card to become available. Next we'll turn to the EB2. So for the EB2 to qualify, you either have to have an advanced degree, meaning a U.S. master's degree or equivalent or higher, or exceptional ability. Equivalency to a U.S. master's would be a U.S. bachelor's or equivalent to a U.S. bachelor's plus 5 years of progressive post-baccalaureate experience. And then for exceptional ability, there's a series of criteria and you would need to meet at least 3. So once you've met those threshold criteria, there's kind of 2 ways to proceed with the EB2 category. One is the National Interest Waiver. So this is a waiver of the normal PERM labor certification process that we'll talk about more later. The National Interest Waiver is when if somebody is engaging in an endeavor that has substantial merit and national importance, and they can prove that they are well positioned to advance that endeavor, and that then on balance, it's beneficial to the U.S. to waive the normal labor certification process, then they can go ahead with this category. We utilize this category a lot for entrepreneurs. This is something where entrepreneurs, if you have a major ownership in a company, you're generally not going to be able to go through the labor certification process for kind of reasons we'll talk about. And because of that, it can sometimes be an attractive option, the National Interest Waiver, because the PERM labor certification process just clearly doesn't work for them. So the other way to get a green card through the EB2 category is through the PERM. So this is company sponsorship. This is where a company says we're going to hire this worker, for a permanent job in the United States. And they go through the labor certification process that we'll talk about in more detail in the next slide. The EB3, so this is for professionals, skilled and unskilled workers. So this is the same PERM process that the EB2s can go through. Again, it's where, a US company decides they want to sponsor a foreign worker, to live permanently in the U.S. Professionals categories for people who have a U.S. bachelor's degree, and the job requires a U.S. bachelor's degree or equivalent. Skilled workers is, where the job requires at least 2 years of education, training, or experience. And then unskilled workers is anything, kind of below that. There's also more limited visas available each year for the unskilled workers category. So that category is often more backlogged than, the EB3 professionals and skilled workers category. The EB4 special immigrant, we won't talk about today, but it is a category that's available. It kind of has multiple different things that it covers. For example, R1 religious workers who want to transition to a green card, that's kind of the category they do it under. And then finally, we have EB5. So this is, although it's under the employment-based categories, it is really an investment green card. So it's based on investing a certain amount of money, either $800,000 or $1,050,000, and then the creation of 10 full-time jobs in the United States. So this can be done either through what we call direct investment, where somebody is kind of starting up their own company that they're investing into, to create these jobs. Or it can also be done through a regional center. That's where kind of the funds are sent directly to a regional center, which kind of pools, multiple investors' funds for these large scale projects that are being done in the United States. Perfect. So let's move to the next slide. So we're going to talk a little bit about the labor certification process, also called PERM. So this is how you get a green card under the EB2 and EB3 categories. It is a company-sponsored process. So for example, sometimes we have clients who are here maybe on an E2 investor visa and their spouse is, the spouse can work anywhere. So sometimes, it's not that uncommon that maybe the spouse is the one going through the green card process for their company while the investor continues to run their own business. It's kind of a three-step process. So the first step and the longest step is the actual PERM, the labor certification. Then the next step is the I-140. So that's an immigrant petition that the company files with U.S. Citizenship and Immigration Services that says, yes, we plan to sponsor this person. And then the last step is the I-485. That's the actual green card application. It can also be done through consular processing, which we'll go over later. So when we look at the PERM, in terms of the steps within it, the first thing to do is to draft a PERM compliant job description. And this is definitely, it's different than kind of a normal job description. So normally you're asking for, anything like, great collaborator, great team player. You're asking for kind of these aspirational, requirements. For the PERM, the government requires that you only list the minimum requirements to do the job in a reasonable manner. The idea behind that is that when they're advertising for this job, they want to make sure that the job is as open as possible to U.S. workers, so that if there are any U.S. workers that could hold this job, a foreign worker is not taking their place. So once you kind of draft that PERM compliant job description, that gets submitted to the Department of Labor on a prevailing wage form. So for the prevailing wage, the government will look at the job duties, the job requirements, the location, and then they'll assign a prevailing wage. And this is the minimum wage that the company has to guarantee that they can pay at the time the person receives their green card in the future. Once the prevailing wage determination is received, then they can actually start the recruitment process. So this is where the company itself is going to have to place advertisements. The regulations specify how long and where the advertisements need to be placed. If it's a non-professional position, so a position that doesn't require, a bachelor's degree, then you would have 3 mechanisms for advertisements. The local state workforce agency, a notice of filing, that's done actually at the physical work site, and then, Sunday postings in the newspapers of general circulation, or one newspaper of general circulation, and then a trade publication. And then if it is a professional position, there's 3 additional, advertisements that you need to place, and there's a list that you can choose from. But you do need to, things like employer's website, campus placement office. So there's a list, but you are kind of, restricted to that list in terms of what types of ads you're going to place. So that recruitment process goes on for about 60 days. Usually the first 30 days is when most of the ads are running. And then we have kind of the 30-day, what we call the quiet period, where the company still needs to accept resumes, vet them to see if they meet the minimum requirements, interview applicants if necessary. And then if they make it through the entire process and they have not found any willing, qualified, and available U.S. workers for the job, then they can go ahead and file the labor certification. If they do find any kind of willing, qualified, and available U.S. workers who meet the minimum requirements where they cannot actually, fairly eliminate that person, they're not required to hire that person, of course, but the PERM process does then have to stop, and it would restart again. The company could either choose to abandon the process entirely, or if they wanted to retest the labor market in the future, wait several months and try again, that's something they could consider as well. So once the labor certification is submitted to the Department of Labor, it can either be certified, meaning approved, it could be denied, or it could be audited. And if it's audited, generally the PERM is an attestation-based system. So that's where when you're submitting the form, you're essentially filling out, you're saying, yes, we place advertisements in these newspapers. Yes, we place advertisements, on this website. But everything is just an attestation that's being signed. When the case is audited, then the government is coming back and saying, okay, provide us with all the proof that you did that. And so any audit notice will usually include requests for things like proof of the advertisements, proof of the resumes, proof of the evaluation sheets from the employer explaining why the applicants were not qualified. And this audit file is something that kind of has to be prepared and kept by the employer, in the event of an audit, because even if the case is not initially audited, it can be audited in later years. So usually if you do get an audit notice, most of the audit file will already be prepared, but then you may want to go over it with your attorney to make sure that it's, kind of addressing all the issues. There's certain things that can trigger, or make an audit more likely. So one is if you have a foreign language requirement and it's not a job like a Spanish teacher. If you have a job where the requirements are outside what the Department of Labor considers normal, that can also be an audit trigger. There also tend to be kind of trends where the Department of Labor will start to audit. For example, for 1 year, they audited, all kind of unskilled workers cases. So, audits, only happen really 20 to 30% of the time. And so it's, and there are kind of trends that go in and out, but, certain things like the foreign language, will make it much more likely that you're going to be audited. For all of these filings, these are all being done with the Department of Labor, not U.S. Citizenship and Immigration Services. Unfortunately, the Department of Labor, the timing has gotten very long. It's taking right now 12 to 13 months for a labor certification to, kind of be, certified or, to reach a final decision. So, that obviously is, delaying the entire process when you're waiting 6 months for a prevailing wage and maybe 12 to 13 months for the labor certification already just based on processing times. This is a process that's over, a year and a half. So it's something to keep in mind when planning for the green card process, that it is something you want to start early. If the PERM is certified, then you can move on to the I-140 stage. So that's where the company is going to file the I-140 petition that says we have the ability to pay the prevailing wage. So they'll have to provide tax returns or audited financial statements. And then they also prove that the applicant themselves meets all the requirements in the labor certification. So for example, if the PERM job required a bachelor's degree plus 3 years of experience, the I-140, you would include that bachelor's degree and employer experience letters outlining that the applicant earned, that 3 years of experience before joining the company. And then the last stage is the I-485. So this is the, the green card application. And we'll talk more about, consular processing versus adjustment of status. Both of them can be done to get the green card, but the I-485 is the adjustment of status process that you do in the United States. You have to consider, timing again. Is your category current? As I mentioned previously, the EB2 and EB3 categories, unfortunately, are backlogged right now worldwide, and we anticipate that that will likely continue. So that is something where you need to build in some extra time, thinking about, if you do want to stay in the United States, if you don't want to depart, and you want to keep kind of being able to work the entire time, that's something you have to carefully plan for at this point. You also want to consider family members, right? So, your spouse and any unmarried children under 21 are able to join as derivatives on your green card application. If you have children who are kind of getting older, you think they may want green cards, and you're concerned about them kind of aging out of eligibility, always good to kind of start sooner. All right, so let's talk a little bit about the two processes by which you can actually get the green card. So one is the adjustment of status and one is through consular processing. So the adjustment of status process is what you do when you're physically in the United States. If you're in the United States in a valid status that permits you to adjust status, you can go ahead and file the I-485. The benefit here is once it's filed, you do have the ability to remain in the United States. So even if your underlying visa status lapses for some reason, you can still stay in the United States in a period of authorized stay based on that I-485. When you file the I-485, you can also file for work and travel authorization. And then for as long as the I-485 is pending, you can continue to renew that work and travel authorization. It is taking several months for those to be approved. So it is a good idea. Again, you want to plan strategically around, especially if you're working or you need to travel a lot, you need to plan strategically around kind of your underlying visa status, to see if you can align all of those goals. At the end of the process, you can be called for an interview with the USCIS officer. You would go in, they could ask you questions about, kind of the underlying job, whether the job has changed, questions about your biographical information that was submitted on the I-485. And then if that is approved, at the end of it, they'll mail you your green card. If you're going through consular processing, and this can sometimes be appropriate for people who either their non-immigrant visa status lapsed and there was no ability to extend, or maybe they need to travel frequently and they're not on an H-1B or an L, and they, there's no ability to kind of wait the, 5 to 6, 7 months that, the travel authorizations are taking. So in that case, you may do consular processing. Through consular processing, the I-140 approval would be sent to the National Visa Center. Once the National Visa Center receives it, they'll send a welcome email. And then you would, the applicant will submit something called a DS-260 and then all the supporting biographical documents to the National Visa Center. Once the National Visa Center reviews the documents, the file is then sent to the U.S. consulate for appointment scheduling. The consulate will then call the applicant for an interview, ask similar types of questions that are asked at the USCIS I-485 interview, and then the green card. Ultimately, if you're approved, you get an immigrant visa in your passport that's usually valid for 6 months. And then when you enter the United States, they enter you, they'll give you a stamp that says I-551. That's proof that you're, green card holder. And then the green card will be mailed to you, usually within a couple months after you enter the United States. All right. So a very common question we receive is who can pay for the green card fee, process when it comes to the PERM in particular. So, because they do, this is a company sponsored process, and the government is sensitive to the idea that applicants may come to their employer and say, hey, I'll pay for this, will you sponsor me if I pay for the whole thing? So because of those concerns, it is the case that the employer must pay all the fees related to the PERM process, both the legal fees and ancillary fees. For example, for fees for posting in the newspaper, all those have to be paid by the sponsoring employer. There can't be kind of agreements to that the employer pays and then the employer will pay them back. Like none of those agreements, are legal. However, when you come to the actual I-140 petition and the green card application, the fees can either be paid by the employer or the employee at that stage. All right, let's talk about dual intent. So whenever you're going through the green card process, you always want to be thinking about, what visa are you on? What are your ultimate goals? How frequently do you want to be in the U.S.? Are you living and working in the U.S.? There are many non-immigrant visas that do not allow for dual intent. So that means that when you get that visa, you have to demonstrate to the officer that you do not intend to move to the U.S. permanently. So visas like the F1 student visa, visas like the TN work visa, these have relatively high standards for non-immigrant intent. You have to show that you have a residence abroad you do not intend to abandon. There are some dual intent visas, the H-1B and the L are kind of the most explicitly dual intent visas. These are visas where it specifically says in the regulations that it's fine basically to be on this visa and to also have a green card process, ongoing. The O is listed here. It's more of a quasi dual intent visa. The language is not as favorable, as it is for the H or the L. That being said, the standard for non-immigrant intent is still lower than that for something like an F, or a TN. So, if you're if you're on an O and you're pursuing the green card process, sometimes it's just a bit easier than if you're on a visa where there's kind of a higher standard, to prove your non-immigrant intent. All right, let's talk a bit about some considerations, when moving from a visa to a green card. So as I mentioned in the previous slide, you do want to be mindful about, what are your goals? If you do want to make sure that you can stay in the United States through the entire process and have unbroken work authorization, that often will take some planning. You want to consider how much time is left on your current underlying visa. For example, if you're on a TN visa and your company is doing the green card process for you, once the I-140 petition is filed, it can be very difficult to renew the TN. The TN, because it does have the standard for non-immigrant intent, even you could potentially argue, well, if I'm going to consular process my green card on this particular entry, I don't have, immigrant intent. That being said, there's many officers that may not accept that explanation, that may feel, well, you have an immigrant petition pending, you have this intent to move to the U.S. permanently, therefore, we don't think you can renew this visa, or you're not eligible for this visa. So you do want to kind of keep that in mind. What type of visa are you on? If you're on an H-1B or an L, it can be much easier, in terms of going from the visa to the green card, because you just don't have to deal with any of those concerns about, proving non-immigrant intent. You want to think about, do you want to adjust status in the U.S.? Do you want to get a green card through consular processing? If you're not on an H or an L, let's say you're on an E2 and your company is sponsoring you, once you file the I-485, you cannot depart from the United States until you get that travel authorization approved. If you depart, your I-485 will be denied. So it is something to consider, when you file your I-485, kind of thinking about, well, if I need to travel, but I don't have the travel authorization yet, like, can I pick a time when it will be okay for me to kind of be in the United States for several months without causing major issues? Or if it's a situation where you just know you're going to have to travel, you're not on an H or an L, maybe you go through consular processing instead. There can be pros and cons to that. You also, again, want to be thinking about your family. Do you want your children to be part of the application? How old are they? Like what are all those concerns? Do they plan to live in the United States full time? Will they be going to school abroad? All things you kind of want to consider when thinking about, the transition to the green card. All right, so let's talk a little bit about the interview. So it's not always the case that you're called for an interview when you're going with USCIS through an adjustment of status. Sometimes they will approve without any interview. Sometimes they will call you for an interview. If you're going through consular processing, they're always going to call you for an interview. So it's important before you go to the interview, you want to review your immigrant visa petition and your green card petition. So you want to look at the I-140 petition filing, however much of it, the employer shared with you, or you can ask for some of the documents. You want to look at your I-485. You want to look back at your PERM. It's a good idea to bring updated, proof of your employment from your sponsoring employer. So if you're currently working there, you may want to bring your pay stubs, an updated letter of employment, an I-485 supplement J. You also want to kind of organize and print and bring with you kind of everything that was previously submitted and anything they request on the interview notice. You want to bring originals of documents like birth certificates, marriage certificates, and then copies as well. Proof of your maintenance of status if you're in the United States. So especially if you've been in the US for a while, they're going to want to see that, you've never violated your status. If there have been status violations, there are sometimes exceptions available for employment-based, applicants through something called, a section of the INA called 245K. But if you have had violations in the past, if you have been out of status, always really important to discuss with your attorney ahead of time so that you can make sure that you have that information. If it comes up with the officer, you can explain why you're still eligible. Also a good idea to meet with your attorney and do a practice interview. Even if you feel comfortable with the information, it can be a nerve-wracking situation. Once you get in there, you may get nervous. Even if there's nothing, there's nothing to be nervous about, or, there's nothing kind of wrong in the information. Sometimes just being questioned by the officer in that environment can be nerve-wracking. So it's always a good idea to just kind of practice some of the questions, get comfortable answering these types of questions, as you go through the interview process. All right, so let's talk a little bit about porting. I think a very, very common question, especially because the PERM process takes so long. People want to know, can I change employers? Or if I do change employers, what impact does that have? What benefits can I take with me from the fact that this other employer started the green card process? And so the truth is that a lot of the time you really, like, let's say you're working for an employer on an H-1B, they start the PERM, they're filing the prevailing wage for you, and now you transfer, to a new employer. At that point, you really take no benefits with you from the old green card process. The new employer would have to start the process completely from scratch. Even if you got to the stage where you had an I-140 approved with a prior employer, you do get some benefit. The applicant gets some benefit where they can, utilize that priority date from the previously approved I-140, but even so, the new employer would have to do the entire green card process for them, including filing a new I-140. However, if you reach the stage of the process where you filed an I-485 green card application and it has been pending for at least 180 days, at that point, there is more flexibility where you can take advantage of something called porting. So this is where the benefit to the new employer is if you've gotten to this point and you're porting, they do not have to do the green card process over. They do not have to file an I-140. All they would need to do, you file an I-485 supplement J, and you file it with proof that the new employment is in the same or a similar occupational classification as the job that was offered to you initially in the I-140. So for example, if, you were a finance manager, and now you're going to be, a CFO, very likely there's going to be an argument that those are the same or similar occupational classification. You're going to provide things like the job duties, the job requirements, the salaries, all of that to kind of help show, make this argument. If it's something where, you were a CFO and now you want to, be a wedding photographer, obviously, there's going to be arguments that are not going to work there. But if it is in the same or similar occupational classification, porting can be a great option for flexibility at this kind of late stage of the green card process. All right, so another very, very common question, again, similar, going back to the process is very long. Can you change employers after you get your green card? And the answer is yes. You can. Once you have your green card, you're a legal permanent resident. You can, it allows you to live permanently in the US, and work here and work anywhere. That being said, when you get your employment-based green card, you and the employer are making this good faith attestation that you intend to continue working for the company that sponsored you in this job. So if you, get the green card and then you quit the next day, that's something that may not look, that may raise questions as to whether or not you misrepresented anything during the process. The place this normally comes up is if you decide you want to naturalize, if you decide you want to become a U.S. citizen in the future. They'll look back at the basis under which you got your green card. They'll look back at your work history. And if there's something that seems off to them, it could potentially create issues where they might kind of trigger an investigation. The worst case scenario, obviously, being them looking into the underlying green card application. And if they found anything like fraud or misrepresentation, rescinding, going through steps to try to rescind the green card. So I think there is no kind of hard and fast rule about how long you need to continue to, work for any given employer after you get the green card. But we usually recommend it's a good idea to continue working there for at least a few months. And if you are leaving, in that short time frame, you want to have some explanation that makes sense, right? So if it's, well, I got, a better job offer with a lot more money, or, my spouse got accepted to a school in another state, whatever it is, you want to be just thinking about, does it make sense? And am I going to raise concerns about whether I misrepresented myself kind of during the green card process?
Great. Thank you very much, Kelly. Excellent information. And we have a couple of questions that came in during the presentation that I will share with you. The first is, could you say a little bit more about the processing times, comparing adjustment of status versus consular processing, which tends to be faster, and of course it depends on the category, but can you share more?
Yeah, absolutely. So, I think that generally, I think adjustment of status is it really depends. So, for example, adjustment of status, I think has potential to be faster. Certainly, I think there's certain places, like, for example, Montreal, where the employment-based cases are just taking over 2 years to even be scheduled there. So I think that very often adjustment of status, especially if you're being sponsored through the PERM, is a better option, just because if you're being sponsored through the PERM, most of the time you are already working for a U.S. employer. So adjustment of status is what allows you to stay in the U.S. and continue working for that employer. So my experience is that that's usually a smoother process. Whether it's faster, again, is hard to say. Like, there are some times where maybe a particular consulate doesn't have a lot of appointments scheduled, and so maybe it kind of goes through faster. But again, there's consulates where, the immigrant visa unit is still very backlogged, and, EB cases are being scheduled, 2-3 years out. So my experience is that adjustment of status tends to be the better option when you're going through the PERM process and you're already in the U.S. working for a U.S. employer. But, certainly either one's viable.
And that's a nice segue to the next question, which is essentially how you navigate the adjustment of status, or I should say consular processing process, applying for an immigrant visa at a consulate if you are in the US on a non-immigrant visa. So this example is saying, what if I'm in the US on a TN visa and I have a pending I-140 for an EB2? Is that possible to do? And what kind of risks, what hurdles should they keep in mind if they're doing that?
Yeah, so I think that like, if you have a pending I-140, it's not that you can't use TN status. You certainly can. You just would know that when you go to the border, if it comes up, it's something where, I think your argument of, you'll tell the officer, on my I-140, there's an option to select either adjustment of status or consular processing. If you've selected consular processing on the I-140, you can bring a copy of that with you. You can show that to them and say, I don't have any intent to adjust on this or have an immigrant visa. My intent is to return to Canada. The consular processing, especially if it's kind of more long dated, if, say, it might not even be for another couple of years. I think there may be many officers that are comfortable with that. You could also bring proof of your ties to Canada, your residence there, that you're maintaining, any financial accounts that you have. Again, though, there may be some officers that just do not accept kind of that nuanced argument and may say, well, even though you plan to consular process, ultimately your intent is to be in the U.S. permanently. Therefore, I don't feel, that we can renew or extend the TN. I think that it comes up much more when you're kind of being, actually submitting a TN application as opposed to just traveling back and forth on the TN. Our experience for clients that already have valid TNs with an I-140 pending is, while you always want to be prepared to answer those questions if they come up, and you always want to select consular processing, to give yourself the ability to make that argument. I think it doesn't come up nearly as much when you're just crossing, on a valid TN.
Perfect. Well, Kelly, I think that addresses all of our questions. So to those of you in our audience, if you do want to continue the conversation, please do schedule a consultation with us, which you can do through our website, or keep an eye out for that email we'll send you after the presentation. But Kelly, thank you for your time. Thank you for sharing your experience. To our participants, thank you for the great questions, and thank you for joining us. We hope to see you on future webinars.
Thank you. Have a nice day.
You too.